We are on the record before the Medical Board of California, Panel A, the Department of Consumer Affairs, State of California, in the matter of the first amended accusation against Rowena Gail Garcia-Chuapoco, MD, Physicians and Surgeons Certificate Number A51290. This is Medical Board Case Number 800-2017-033549 and OAH Case Number 2025-040958. Today is May 14, 2025. It is now 2:11 p.m. This is the date and time set for oral argument in the notice of hearing for oral argument after non-adoption of a proposed decision. The panel and parties are conducting this oral argument in person, and I am appearing by WebEx video conference. My name is Sean Gavin. I am an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the oral argument. First, to ensure that there's a quorum, I'll call the panel members and have them confirm their attendance now that we're on the record for this hearing. We'll start with panel chair, Dr. Michelle Bolat.
Present.
Next, panel vice chair, Dr. Belling Tsai.
Here.
Then Annie Chung.
Here.
Dr. James Halzer.
Present.
Marina Torres.
Present.
And I understand Mr. Watkins is not present, but the members who are present constitute a quorum. I'll now take the appearances of the parties, starting with the Deputy Attorney General.
Deputy Attorney General Thomas Osley appearing for the Medical Board of California.
Thank you. And for respondent?
Good afternoon, Your Honor. Cyrus Tabari for Dr. Garcia-Chuapoco, and Dr. Garcia-Chuapoco is also present with me.
Very good. Thank you. We are also joined by a court reporter who is invited to identify himself and his CSR number now.
My name is James Peters, and my license number is 10,063. And if Mr. Osley could get just a little closer to the mic, he's a little faint.
Is this better?
He didn't hear you.
Is this better?
Yeah, it's better. If you could get just a little closer. It seems like that microphone seems to be a little faint to me.
How's this?
Perfect.
All right. Thank you for that. For oral argument, the following process and time limitations will apply. First, respondent will have 15 minutes for opening argument. After that, the DAG will have 15 minutes for opening argument. Then respondent will have another 5 minutes for closing argument. Finally, the DAG will have another 5 minutes for closing argument. I will strictly enforce those time limits. As a reminder to the parties, the board has already had the benefit of reading your briefs. Oral argument should be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panelists may ask questions of the parties to clarify the arguments, and they can't ask questions that would elicit new evidence, but they can ask questions. And either I or any panel member may ask a party to support the party's argument on a matter with a specific citation to the record. At the end of the oral argument by counsel, I will offer a respondent an opportunity to address the panel. If she elects to address the panel, I will place her under oath. After oral argument, the board will go into closed session to deliberate. The parties will not receive a decision today, but will receive it sometime in the future. Mr. Tabari, any questions before we begin?
No, Your Honor.
Mr. Osley?
No, Your Honor.
All right, then in accordance with the time limits that I laid out in a moment, I will start the timer as soon as you begin, Mr. Tabari.
Thank you, Your Honor. Ladies and gentlemen, we're here today, as you know, because the board non-adopted the decision by Judge Cox, the ALJ, who heard this case back in January. I'm not going to go into too much detail because I put it in our written argument. I tried to be as detailed as possible in the written argument. And I'm not going to just reiterate everything that I put in there because I assume that you read everything already. So I'm not going to belabor the point. There's a couple things I do want to just emphasize that are in there. First of all, under Business and Professions Code section 2335, those of you deciding this case are bound by, or not bound, but are required to give great weight to the findings of fact by the administrative law judge, except to the extent that those findings of fact are controverted by new evidence. So since there's no new evidence to be decided in this case, this dictate by Business and Professions Code Section 2335 should apply as you consider the evidence here. I also want to talk a little bit about Business and Professions Code Section 2229, which I'm sure you're all familiar with. This is the provision that says that protection of the public should be the highest priority for the board. And I don't think there's anybody that disagrees with this. But as you review the evidence in this case, I think there's a couple salient facts that you need to keep in mind. First of all, Dr. Garcia-Chuapoco has performed over 15,000 colonoscopies in her career. And this is the only time one of her patients had an adverse outcome. She's never had a patient suffer a perforation or any other of the other more common and recognized risks of undergoing colonoscopy or any other endoscopy procedure. So in that regard, this was a single outlier situation. Number two, subsequent to this event, Dr. Garcia-Chuapoco talked to her partners and convinced them that they should start using certified registered nurse anesthetists for all endoscopy procedures that they perform, CRNAs. And as I'm sure most of you know, a CRNA is a licensed professional that acts independent from the physician during the course of the procedure. And so to the extent there are concerns about Dr. Garcia-Chuapoco monitoring patients or being aware of a patient's status, that concern has been completely alleviated and mitigated by the fact that she now has a CRNA with her at all times. And so because of that, there's no reason for her to be the subject of discipline to protect the public going forward, because even though she denies that she was responsible for what happened here, that in a legal sense, she denies that there was any breach of the standard of care, and I think the evidence in the record amply supports that. Nonetheless, she took this extra step of now having a CRNA present, which in retrospect, if there had been a CRNA present for this case, this wouldn't have happened. And so we know moving forward, the purpose of discipline by the medical board, as I'm sure you all know, is not to punish physicians for past acts. It's to protect the public moving forward. And Dr. Garcia-Chuapoco has taken the step of requiring that a CRNA be with her at all endoscopy procedures in a way to protect the public that's far greater than any probation or probationary terms could apply in that regard. So to the extent that there's a concern about her moving forward and the need to protect the public, that has been alleviated by the fact that she's using a CRNA. I wanted to make a couple of comments about the written argument that was submitted by Mr. Osley on behalf of the board. And really, I'm going to go to his conclusion section of his written argument. The board initiated this disciplinary action against Dr. Garcia-Chuapoco by the filing of an accusation. And the accusation is what limits the scope and extent of the evidence and arguments that can be presented against Dr. Chuapoco. There are four things that are alleged in the accusation: that Dr. Garcia-Chuapoco did not properly monitor this patient, that she did not properly communicate with the nurse that was assisting her on the procedure, that she did not recognize and address the fact that the patient was having some distress, and with regard to her documentation that she prepared. Those are the four bases for discipline that were alleged in the accusation, and those are the only four things that were addressed by the expert that testified on behalf of the board. However, in the conclusion section of the written argument submitted by Mr. Osley, the first thing he says is that the respondent did not properly supervise an inexperienced nurse. Now, whether this nurse was experienced or not was not a subject of debate in the hearing. The record does show that he'd been a nurse for 10 months, but there was no evidence that he was inexperienced or that Dr. Garcia-Chuapoco should have taken any extra steps because of his alleged inexperience. She was there to do a procedure. He was the nurse that was provided by the facility to perform the procedure. There's no extra step that she should have taken. There was no evidence submitted by the board. Certainly the board's expert did not say anything about the relative experience or inexperience of this nurse. So the fact that this is the first thing that Mr. Osley had to argue really calls into question the credibility of all of the arguments that were presented here on behalf of the complainant. The next thing that he says in that same sentence is that Dr. Garcia-Chuapoco created false and inaccurate medical records that concealed patient one's low oxygen saturation levels during the procedure. And I'm sure you've all seen the evidence of that at one time during the procedure, there was a oxygen saturation of 39%. Now, at that same time, the patient had a more than adequate blood pressure and a respiratory rate of 22. And shortly thereafter, she had a normal oxygen saturation rate before then it dropped again. And there was testimony at the hearing, and those of you who are physicians who have familiarity with O2 sat monitors know that if this device is something that clips onto the finger and it can become loose and can stop recording properly what the oxygen saturation level is. And when that happens, it's just readjusted and it's fixed. In this case, the testimony by Dr. Garcia-Chuapoco and the nurse, Mr. Verre, was consistent in that neither one of them heard an alarm sound that there was a dangerously low oxygen saturation level. Number two, we know that these oxygen saturation monitors have alarms that are supposed to be set to go off if there's a dangerously low oxygen saturation level. And number three, Mr. Verre, the nurse, admitted in his testimony that it was his responsibility to make sure the oxygen saturation alarm was properly set. Now, he did go on to say he didn't know how to do that, and he didn't know how to default to turn it off or turn it on. But again, that's not something that can be placed at Dr. Garcia-Chuapoco's feet. That's not her responsibility. That was the nurse's responsibility. And Judge Cox, in her decision, indicated that there's some question as to whether that 39% was truly an accurate oxygen saturation level, or was it an artifact? And when you're looking at that evidence, you have to keep in mind that the burden of proof for the complainant is clear and convincing evidence. And I would submit to you that there was not clear and convincing evidence to show that that was an accurate oxygen saturation level at the 39%. And in terms of the, going back to the argument, Mr. Osley goes on to say, for several weeks, respondent had the opportunity to correct false information given to investigative bodies, but she did not. Now, I think one of the things that he's alluding to there is the report that was submitted to the medical board pursuant to Business and Professions Code section, I believe it's 2240, but let me just double check that. Yeah, 2240. So under Business and Professions Code section 2240, there's supposed to be a report to the medical board if a death occurs to a patient that underwent a procedure in a ambulatory surgery center, which is what this was. And that report was properly filled out and completed and submitted to the medical board. There was nothing in the accusation that accused Dr. Garcia-Chuapoco of completing this form improperly. It was really a red herring argument that Mr. Osley brought up at the hearing before Judge Cox. And even though it's one that Judge Cox did not adopt, in fact, she didn't really address it even because it's not part of the accusation, he nonetheless has reiterated that claim in his closing conclusion here in the written argument that he's submitted to you. Under Business and Professions Code section 2240, there's some specific things that need to be reported, and those things were reported by Dr. Garcia-Chuapoco when she sent the form into the medical board. In fact, she went above and beyond in attaching a summary of the case to the form, which was not required by the form. There's a form that you fill out, and it's in the records, and I can identify it for you if you need me to. But she completed that form properly. And again, it was not part of the accusation that she didn't complete that form properly. I'm not sure what else he's talking about in terms of investigative agencies. There was some argument early on in this written argument that the coroner's office somehow didn't have proper information, but that was never specified. And more importantly, there was no expert testimony about that. There was no expert testimony about what the coroner should have been told or wasn't told, or any inaccuracies that were provided to the coroner's office. And if you have a chance to look at the Seton Medical Center records, and just as a reminder, when the colonoscopy was done at a surgery center near Seton Medical Center. And so when 911 was called and EMS came, they transported the patient to Seton Medical Center. And at Seton Medical Center, she was in the ER. Dr. Garcia-Chuapoco went right away to talk to the physicians there. And the concern was that she'd had a cardiovascular event because she had some ST elevations on an EKG. And so they took her directly to the cath lab. And in the cath lab, it was found that all of her coronary arteries were clear. There was no signs of any occlusion or anything that could have caused an infarct of her heart. And so then she was completely worked up at Seton Medical Center. They could never find a reason to explain what happened to this patient. However, if you look at the death summary that was performed by Dr. Sun, and it's page 336 of your whole set of the clerk's record, and read through that, Dr. Sun clearly had the information of what happened at the surgery center with the endoscopy. So, what happens in situations like this is that you can try to take an argument and divorce it from reality, this notion of false and incomplete reporting. And yet when you then look at the reality of the situation, it's apparent that nobody had any questions or issues about what happened at the surgery center. The coroner's office properly understood what happened. The physicians at Seton Medical Center understood what happened. I think what Mr. Osley's getting at is this claim that he won't let go of, that there was somehow this hypoxic event in the middle of the colonoscopy, which is evidenced by the 39% oxygen saturation level, which ignores the fact that she had a normal respiratory rate and a normal, if not slightly hypertensive blood pressure. And then subsequently, her blood pressure still remained normal or hypertensive. If this was a patient suffering a respiratory arrest during the procedure, her blood pressure would have crashed. And that did not happen. It didn't happen until after the event, when they then called the code and tried to resuscitate her. So I think that the board not only failed to meet its burden of proof that she suffered some hypoxia during this event, I think the evidence is pretty clear that she did not suffer any hypoxia during the
You
event.
have 1 minute remaining. Sorry to interrupt. 1 minute
Most
remaining.
likely, this 39% was simply a result of artifact. In terms of the monitoring, what's interesting is that Judge Gavitt is off to my left right here. I can see the screen if I look at it, but if he were to hold up some fingers right now, I wouldn't be able to see how many fingers he's holding up because I'm looking at you. That's exactly what Dr. Garcia-Chuapoco was doing during the colonoscopy. She's looking at a monitor that shows what's going on during the colonoscopy. That's her primary responsibility. It's up to the nurse to monitor the vital signs. She could have looked off to the side to look at the monitor for the vital signs, but her focus is on the screen for the colonoscopy. That's her main job that she's there to do. Dr. Hargraves talked about the journal article that's in the evidence that shows that all of the gastroenterology societies, all of them agree that a nurse, a registered nurse, is sufficient to monitor.
Mr. Tabari, I'm sorry to interrupt. That's your 15 minutes right there, though.
Okay, thank you. I'll submit it on that.
All right. Thank you, Mr. Tabari. Mr. Osley, you'll now have 15 minutes, and I will begin the timer as soon as you begin speaking.
Thank you, Your Honor. Good morning. I'm sorry. Good afternoon, Board. I think it's probably best if I just pick up right where Mr. Tabari left off. First of all, the patient did not have one hypoxic reading of 39%. They had two hypoxic readings that were 11 minutes apart. The evidence showed that the patient was hypoxic for 11 minutes during this procedure. And as I go through the evidence, I'm going to go point by point over all of the things that show that the decision by the ALJ was either inconsistent with the evidence that was presented or deviated from it in some point, or was inconsistent with what the evidence was. And I think starting right there with the issue of whether or not the patient was hypoxic during the procedure, the best evidence to go to is respondent's expert, who in his expert report, which is Exhibit D on page B10, he says the patient was hypoxic during that time period. He also testified in volume 11, page 100, line 22, continuing on to page 101, that the patient was hypoxic for 11 minutes. So the evidence that the patient was hypoxic were those two readings showing the O2 saturation was inconsistent with life, both I believe at 11:10 and then 11:21. The respondent's own expert, who both said so in his report and testified so, and the complainant expert. But what I'm going to do is try and focus on the evidence that's most favorable to respondent. Most of the points I'm going to make are going to refer to what the respondent's expert found. And I think the most important thing to do, well, actually, before I do that, I want to address one of the things about the ALJ's report. This issue of whether or not there were adequate medical records. I'm going to get into it in more detail with the respondent's expert, but is having an O2 saturation inconsistent with life for 11 minutes, is that something that's pertinent to a patient's care? Dr. Hargrave, the respondent expert, said yes. Not specifically to that question, but if it has to do with the care of the patient, if it has to do with something that's important, it needs to be documented. Does it matter if it's in an incident death report that's being given to the MBC? No. Dr. Hargrave says that's a medical record and it needs to be accurate and complete. Does it matter if it's to the coroner? Dr. Hargrave says it needs to be accurate and complete. One of the questions that was brought up, and this was throughout the testimony, was when was the chart note that said that the patient tolerated the procedure? When was that chart note completed? The respondent had testified that that note was completed a minute to 2 minutes after the procedure. And it's not in front of me, but I'll grab the actual site and give you the actual part in the transcript where she says that. She completed her chart note. But if you look at paragraph 34 of the ALJ's complaint, of the ALJ's decision, she doesn't find that she completed her report. She says that she abandoned her report and finished it later. Well, when did she finish it? She finished it 10 weeks later. She had 10 weeks to correct that misinformation. She had 10 weeks to correct the O2 saturations. She did not. She did not contact the coroner to update the information. She did not contact the MBC. In fact, the MBC death reporting report was submitted on April 30th, and the chart note was completed a week before that. But Dr. Garcia-Chuapoco had said that the reason, and she testified that the reason why that chart note was inaccurate about the patient tolerating the procedure well, the reason it was inaccurate was because it was signed and locked, that it was completed, that she couldn't edit it. But that was not true. And the ALJ report is not only silent as to that, it actually goes on, and I believe it's on paragraph 38. All the judge says is she started her chart note and finished it later, without mentioning that she left out the O2 saturations. Now, the O2 saturations. The judge in her findings says that that could be artifact. And she says that the complainant's expert is not credible because he found that those O2 saturations were consistent with the injury that the patient suffered, ultimately resulting in her death 3 days later. However, Dr. Hargrave made the same findings. So the judge's decision to find the complainant expert not credible for, seeing the O2 and then, following on with the logic that that was also the cause of the patient's injury, she doesn't apply that to the respondent expert, which is just inconsistent. Before I go into more about the expert witness, I want to talk about one other inconsistency, and I want to find it here to make sure I can cite the pages. Well, so one of the issues is the ALJ's own findings show that the complainant's expert, Dr. Hurwitz, that the low O2 would have been readily apparent. She takes issue with that when criticizing Dr. Hurwitz, but in her decision on paragraph 25, she says that it was readily visible and readily apparent. So that was another reason for critique of Dr. Hurwitz, but her own paragraph 25 is consistent with what Dr. Hurwitz testified to. And this unwarranted assumption that it was irrelevant, or sorry, she criticizes Dr. Hurwitz saying it was an unwarranted assumption that Dr. Chuapoco could see the vital signs, but she does make a factual finding of that very issue in paragraph 25. Going to the ALJ's decision in paragraph 48, she says that the alternative explanation for this low O2 saturation of artifact, that was strong enough that that it would be an unreasonable assumption that the O2 was the cause of anything. It was the complainant's position, both at the hearing and now, is that it is not for the physician to decide whether facts are relevant or not when it comes to the potential cause of harm to a patient. If the vital signs, or that the O2 saturation is 38 and 39%, you document it. If you think it's artifact, document that you think it's artifact. There's nothing stopping the respondent from documenting all the reasons why she did not believe that those numbers were correct. But what was left was a picture that this patient handled the procedure well, everything was fine, and then they crashed afterwards. The coroner's report says that, and that is not true. This patient was not able to be roused after the procedure, and that is inconsistent with the truth. And there was 10 weeks to resolve those inconsistencies, and that was not done. And that is what the issue that was taken at hearing and the issue now. Going back to the complainant's expert, respondent's expert, Dr. Hargrave. I don't think it was uncontroverted. He's an excellent physician, 15,000 procedures, his CV, everything showed that he's an excellent physician. However, when asked simple questions like, what is the standard of care? Can you define it? He couldn't, but even when asked under cross-examination, specifically, do you agree with this definition? His definition of a simple departure was, tell me some facts and I'll tell you if it's a simple, which is not a definition of what the standard of care is. And then an extreme departure, he defined as needing patient harm. If a patient's harmed, that would be an extreme departure. That is not the standard of care or even close. And that was, the ALJ's decision is mute on that point. She does not say anything about the fact that the expert could not even say what the standard was. There's another equally concerning problem, which is the Dr. Hargrave, and again, doesn't go to his expertise as a physician, but as an expert witness. He said that 90% of his decision on whether or not Dr. Chuapoco breached the standard of care was on the fact that the nurse admitted to wrongdoing. He says, well, the nurse admitted they did it. So clearly, Dr. Garcia-Chuapoco didn't do it. The nurse never admitted anything. That simply isn't true. And if you look at the transcript, and again, if you ask, I'll give you the cites. Dr. Hargrave refused to admit that he misinterpreted that. It went on for pages of him saying, well, I'm not going to talk about angels dancing on pens and around in circles. But put simply, he said he was 90% of his decision-making was on the fact that the nurse admitted they were wrong. When it was shown that the nurse admitted no such thing, And he was asked, does this change your opinion in any way? He said no. It was 90% based on that. And even though that house of cards fell down, his opinion did not change at all. And that just goes to basic credibility. Is he there to try and help the finder of fact, or is he biased in some way, and does he have an agenda? And if you look at the questions that were done as hypotheticals, asked in general about what the standard of care should be, he gave forthright, direct answers that were detailed and completely consistent with Dr. Hurwitz. Asked specifically about the facts in this case, and it would go around in circles. And you don't need to take my word for it. You can read the transcript and read his testimony. The other issue, and I want to get directly to this because it was important because Dr. Hargrave said it, is that medical records need to be done timely. He said, you know, if someone goes on vacation and they come back within 10 days and they finish them up, that'd be one thing, but they need to be accurate. They need to be done timely. He said 10 days would be a breach, but as long as they're accurate, it's okay. But in this case, we have 10 weeks. Now, he wasn't asked specifically about the 10-week lapse in this case. He was just asked in general, when is it a breach when they're past due? And he said 10 days, and we're at 10 weeks. And he said, if it goes to why a patient was harmed, then they are absolutely part of the patient record, and they should be in there. And they just simply weren't, and that was never corrected. So the other issue is what did the patient know at the time? The patient was told, and in the whole discussion under informed consent, the patient was told that they would be given moderate sedation administered by a nurse with physician immediate supervision. So what is immediate supervision that the patient was told would be had over the nurse administering the anesthesia? And that's on volume 3 of the trial transcript, page 17, line 22, about this having immediate supervision. According to the testimony from Dr. Hargrave and Dr. Chuapoco and the ALJ's findings, there's no need for any discussion with the nurse and the physician, that the supervision can be as simple as just letting the nurse do whatever they want and then explain later what's going to happen, except for the administration of drugs. In Dr. Hargrave, the respondent's expert says that no, the nurse could not administer drugs without permission. But later, there's now this controversy of whether or not the nurse did administer additional doses of Versed and Demerol without permission. But that's not in the reporting. Did this nurse give those additional doses without Dr. Chuapoco's permission? And given the facts that we know of how this case ended, is that relevant? Should that have been charted? That a nurse administered, additional doses with no permission from the treating physician? Was that what the patient was told would happen and how things were supposed to go when they gave informed consent? No. And it's confusing because the Demerol, Versed, and Benadryl were all given at about the same time. But the Benadryl, which Dr. Chuapoco says she did get permission for, was in between the Versed and the Demerol. So the communication does not make sense. It's not properly documented.
You have 1 minute remaining.
Going to what Dr. Hargrave said is that ultimately a doctor doing a procedure is the captain of the ship. Those were his words. They're ultimately responsible. They need to know what's going on. They need to act appropriately and act with full information. Dr. Chuapoco said that she would administer more narcotics if necessary, but also that she wasn't monitoring vitals. And it's inconsistent that you would make a decision about a patient getting additional pain medication without even knowing what their status was. And so for all of the reasons described, I think that the decision should be non-adopted.
All right, thank you, Mr. Osley. Mr. Tabari, you have 5 minutes for closing, and I will begin the timer when you begin speaking.
Thank you, Your Honor. I'm going to start with that last point brought up by Mr. Osley, and this is exactly what I was talking about in my earlier argument. He spent some time going over what the patient was told in her informed consent discussion. If you look at the accusation, there's not a single word in the accusation about that. If you look at the testimony from Dr. Hurwitz, he never talked about that either. This is according to Mr. Osley that that's a breach of the standard of care, but he's not an expert. He's not allowed to present evidence of that. He's arguing this, but there was no evidence in the record to support that. It's the same thing with this 10 weeks issue that he keeps talking about. The 10 weeks has to do with the initial colonoscopy report and then a later one that Dr. Garcia-Chuapoco did where she removed where it said the patient was given discharge instructions. He ignores all of the other records of what happened at that time. There's the printout of the vital signs, which is how he got this information about the pulse oximeter. There's the code blue records. And in fact, ironically, Dr. Hurwitz, when he testified, wasn't even given the code blue records. So Mr. Osley gave their expert an incomplete set of records to decide the case on. The code blue records clearly delineate what happened. Dr. Hurwitz also admitted on cross-examination that this 11 minutes of hypoxia that Mr. Osley keeps talking about, he couldn't support that without speculating. So the complainant's own expert said, I can't say that there was 11 minutes of hypoxia. And that second O2 sat number, that's when the patient coded. So it wasn't that there was an 11-minute period of time. And what he ignores is the otherwise adequate vital signs that were ongoing at the time. So, if you look at Mr. Verrey's note that he did, if you look at this testimony, that night he wrote out an incident report of what happened, and it's on page 888 of the clerk's record. And if you go through that, you'll see that when he documented the vital signs, he said no evidence of cardiac or respiratory distress the whole time. So that day, we know that he didn't think that that O2 sat number was a legitimate number. And Mr. Osley's suggestion that doctors are supposed to document in the medical records when they see an artifact, Dr. Hurwitz didn't testify to that. There's no expert testimony to support that. And I can tell you that in over 35 years of representing doctors in hospitals and malpractice cases and before the board, I've never seen a doctor have to specifically say there was an artifact that I ignored at a certain time. Finally, what's going on here is that this patient had an arrest after the colonoscopy was done. And in a surgical setting, if the surgeon documents that the surgery went well without any complication, and then the patient codes in the PACU, the surgeon's note is still accurate that nothing happened during the surgery. And that's exactly what happened here. Dr. Garcia-Chuapoco documented that nothing untoward happened during the colonoscopy until once she pulled the scope out, the colonoscopy is over. And then what happened to this patient was subsequent to the colonoscopy. So there's nothing inaccurate about her records. And the code blue records and all the rest of the records from the facility clearly document what was going on with this patient afterward. So this notion that there was some sort of falsification or improper notification of what occurred is just fanciful and not supported by any of the testimony or any of the evidence.
1 minute remaining.
The thing about Judge Cox noting at one point that Dr. Garcia-Chuapoco was not aware of the vital signs, and then her also saying in paragraph 25 that it was apparent, that goes to what I was talking about earlier. She could have looked over to the monitor to see what the vital signs were, but she was focused on the monitor for the colonoscopy. And those two things are completely consistent. This suggestion that there's an inconsistency in Judge Cox's decision is belied by the actual language and evidence of what she said in there. In closing, I submit to the board here that the evidence was decided by Judge Cox, and based on her review of the evidence, her determinations of the credibility and the weight of the evidence, that it supported the finding that this accusation should be dismissed against Dr. Garcia-Chuapoco, and I urge the five of you to adopt that decision. Thank you.
Thank you, Mr. Tabari. Mr. Osley, I'll begin your 5 minutes when you begin speaking.
Thank you. So this idea that Judge Cox didn't decide the issue of the late reporting was somehow because she didn't find it was relevant. She didn't say that in her decision. She didn't say, I didn't find this to be an issue, or I found that irrelevant. It's just simply silent to it. And it's inconsistent with all of the evidence that's in the record. And put simply, there's no other way to find the way she did and address that it was 10 weeks late without addressing that respondent's expert says that's a problem. She just glossed over it and said, oh, well, she stopped writing her chart note to deal with the patient. She abandoned it. That's not what the respondent testified to. The respondent testified that it was completed, and then she turned her attention to the patient. And that is why it was inconsistent. That is why that note did not contain the fact that the patient was unable to be browsed, was because that note was completed. And that information was then given to the coroner, and that information is not accurate. It's self-serving. It shows that everything was done correct by Dr. Garcia-Chuapoco, and some other intervening cause happened after the procedure. Well, that's not what happened. The patient was never able to be roused. But that's not what was submitted to the medical board, and that's not what was submitted to the coroner, and that was not what was in the patient records. And again, you don't need to go any further than the respondent's expert. He says, throughout his testimony, when asked in general about doing patient reporting, that it needs to be accurate, and if it goes to, especially to the cause of an injury or some pertinent fact like that, it needs to be accurate and documented, and it doesn't matter what type of document it's put in. It's part of the patient record. And for Judge Cox to simply ignore that completely and ignore the inconsistent testimony on that point. Now, granted, Judge Cox says, oh, well, I think it's in paragraph 34. She started her report and then stopped to do resuscitation of the patient. She ignores that she testified inconsistently previously. And she also ignores that that testimony regarding stopping it and going back later, that was after it came out that it was 10 weeks before it was signed. And again, no discussion about that. It's just inexplicable that Judge Cox would not make some determination on that point. And again, going back to Judge Cox's decision, those factual findings that she makes are, again, inconsistent in themselves. This idea that what Dr. Hurwitz decided questions his credibility because he felt that the O2 saturations were relevant to the patient's condition. And she found him not credible for his factual assessment. For the reason for saying, and it disagrees with the way she found the facts, which was that the O2 saturation could have been artifact or something else, or not necessarily a cause of anything. Well, the testimony was that those things are possible. The sensor could come loose, but how can you have two readings, not one reading, but two readings, 11 minutes apart, within 1% of each other, but both are because of a loose reading? And I believe it was Dr. Hurwitz, the complainant's expert, who said, if there's a problem, if there's any question that the O2 is at 39%, you stop what you're doing and you deal with it. You don't continue on. The respondent's expert said that it was impossible for Dr. Chuapoco to have known anything was wrong because it is inconceivable that a physician would go forward knowing the O2 saturations. But
1 minute remaining.
But he did not apply that to to the nurse. For the nurse, it was completely plausible that the nurse knew these things and just didn't communicate them. So again, going back to these inconsistencies, this inconsistency with how the evidence was evaluated, but most importantly, this idea that a patient could be hypoxic for 11 minutes, that not to be documented, not to be corrected for weeks, for that information to be submitted to other agencies, knowing it's not correct and not accurate, and for that to be okay is inconceivable. Thank you.
right, thank you, Mr. Osley. Mr. Tabari, does Dr. Garcia-Chuapoco wish to address the panel herself?
I know she's here to answer questions, but she doesn't have anything to say affirmatively.
Okay. Well, to the extent that she may be answering questions, I'll still place her under oath so that way any answers have the effect of evidence. Dr. Garcia-Chuapoco, can I have you raise your right hand, please? Do you solemnly swear or affirm under penalty of perjury that the matters about which you testify will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, very good. Can I have you say and spell your name so the record is complete, please?
Rowena Garcia-Chuapoco. ROWENA-GARCIA-CHUAPOCO.
All right, thank you. At this point, I'll give the panelists a chance to ask Dr. Chuapoco any questions, or Dr. Garcia-Chuapoco any questions they might have. I'll start with panel chair, Dr. Bolat.
Your Honor, I have no questions.
Vice Chair, Dr. Sai.
I have one question. Looking at the record, I don't, obviously, it's stated in the record the time at which the vital signs were taken. And of course, everybody's arguing over that 10 minutes. I noticed that after 11:14, there was nothing taken. And before that, vital signs were taken every 1 or 2 minutes. Was there some redaction of those information, or is it just the monitor or whatnot? I wanted to know what that discrepancy was.
Yes, thank you for asking that. Yes, sometimes when the pulse oximeter gets loose, we put it back on. And if we feel that it gives an accurate reading, we hook them up to another monitor, which does not record anything. And I think the reason why there's nothing in between those readings is because the patient was hooked up to another monitor. It's very inconceivable. I have a 30-year career. I have done so many colonoscopies and upper endoscopies. It's inconceivable for me to see a saturation of 39%, not do anything about it, much less allow 10 or 11 minutes to pass, continuing my procedure. Whenever I do my procedure, I aim to do the best I can. I focus most of my attention to the monitor because I don't want to perforate. I want to find every lesion that I can find. But of course, I take the time to glance at the monitor. I may not look at it for a long time, but I look at it. And if that 39% happened while I did not see it, or if my eyes were not on that monitor, I expect the nurse to alert me. And that's the reason why the nurse is there, is to 100% monitor the patient and let me know what is going on. Thank you.
Dr. Sai, any additional questions?
No, Your Honor.
Ms. Chung, any questions?
No, no, I don't. Thanks.
Dr. Helser?
Thank you. Dr. Garcia-Chuapoco, I'm having a difficult time understanding, given the saturations that were displayed in the record, why there wouldn't have been a very loud alarm sounding in the room at the time. I think that both the low O2 sat and the fact that the pulse oximeter may have come off, both would have triggered an alarm condition in the monitor. And I'm wondering if the alarms were in fact enabled.
Doctor, that is my same question. I have done, as I said, I have done so many of these, and all our monitors are supposed to have alarms. Occasionally, because the alarm is loud, the nurses may turn it down to a level where they themselves cannot even hear it. So I'm not exactly sure. I don't go and ask the nurses, is everything okay? Are the alarms working? Because that's their job. This was not the first case of the day. This was actually the last case of the morning. So I cannot explain why there were no alarms triggered, but that's one mechanism where we can know, even if we're not told by the nurse, that something is wrong. The pulse, the O2 sat is lower, the blood pressure is lower, anything will trigger that alarm. The heart rate is lower or higher, whatever, it will trigger the alarm. So at that time, no alarm was triggered.
It was my understanding from reading the record that Mr. Verret testified that that he had never heard an alarm sound during his tenure at the endoscopy center. And is it possible that these alarms were routinely disabled or turned down so the volume was very low?
Doctor, I cannot answer that question. As I said, the doctors are not in charge of the monitors. The charge nurse, together with a monitoring nurse, have that job early in the morning when they come in before the first patient. We have several nurses at that facility that rotate positions, PACU, pre-op, and sedation monitoring. So I'm not quite sure what happened that day, if there was a malfunction or whether the alarms were shut off or turned down. I cannot answer that question.
As a physician supervising a nurse administering sedation, what is your role in ensuring that there are safe conditions for the sedation?
Sir, when we start the procedure, I tell the nurses I'm in charge. I will call all the shots in terms of giving the sedation. If you look at the record and the times that the sedations were given, they were so close to each other. I know, because I've been doing this for most of my career, all of my career, that I'm supposed to wait 1 to 3 minutes. I know when the onset of action is for each of the drug that I administer. I know when the drugs peak. So I am not going to give Versed at 11 o'clock, another Versed at 11:01, another Benadryl at 11:03, another Demerol at 11:04. That is just not how I work. That is just not how I conduct my sedation monitoring. Sedation instructions to the nurses. I always tell them what they're supposed to do. If they do it on their own and they do not inform me, then I can't tell. I'm not watching their hands. I'm not watching what they're doing, because my focus is 100% on the monitor, and I'm watching and looking at the colon and making sure I'm performing a safe procedure.
Thank you. I just have one more question. I believe you testified, and Mr. Tabari mentioned this too, that it seems unlikely the patient was hypoxic because the blood pressure was normal. In my experience, it's possible to be quite hypoxic to have normal blood pressure. Can you perhaps support that assertion?
I cannot. Based on what we have an O2 sat of 39% and a blood pressure that's high. She was a hypertensive that was on 3 antihypertensives. She came in, it was normal. She came into the room and her blood pressure was high. So it had been at least 24 hours. She was off all her medications. So I'm assuming that the blood pressure was high because she was not on her medications for over 24 hours. And you see that she maintains that kind of blood pressure all throughout until the end of the procedure. And she only really started to crash after, when she couldn't be aroused, and we started to do all our resuscitation efforts.
Thank you. I have no more questions, Your Honor. Thank you.
Thank you.
Ms. Torres, any questions?
None for me.
All right. In a moment, I'll ask if the matter is submitted for the people and complainant. Mr. Osley, is the matter submitted?
Your Honor, I would like to make a comment on one of the questions that was asked, if possible. Is that allowed?
Well, not exactly. We have sort of a strict policy that we need to follow. It's in terms of the sequence of events here. Are you attempting to direct the board members to part of the record that would clarify one of the questions that was asked?
Yes, if I can do it that way, I'd just like to point to I can just point to one of the sections in the ALJ decision and leave it there.
Yeah, that's just fine.
Okay. So what I would like to do is point out on page 9 of the ALJ's decision, all of the blood pressure and O2 saturation readings are all summarized there, and that's complete and accurate according to all the information that's known.
All right. With that, Mr. Osley, is the matter submitted?
Submitted, Your Honor.
And Mr. Tabari, for respondent, is the matter submitted?
Can I make one comment on that, what he just said? On that.
Is it to point the panelists to something in the record?
Correct.
Yes.
So, and it's on page 9, and in response to Dr. Hilzer's comment, I didn't mean to say that just at that time, a high blood pressure doesn't suggest that she was hypoxic. It was really, if you look at the whole 11 minutes later, she still has a relatively hypertensive blood pressure, and that would be inconsistent with 11 minutes of hypoxia. The blood pressure would start to come down after that. And with that, Your Honor, we're willing to submit it.
All right, that concludes argument in the matter. The record is closed. The case is submitted, and we are off the record. The panel will now deliberate in closed session in accordance with the agenda.
Thank you, Your Honor.
Don't leave just yet, counsel. I want to give Mr. Peters a chance to ask you to spell any words or terms, and also perhaps to get contact information if he needs it.
Yes, contact information is really the only thing I need. So just email and phone number. We'll start with Mr. Osley.
My phone number is 415-510-3871. My email is my name, Thomas Osley @doj.ca.gov.
And Mr. Tabari.
Yes, my phone number is 408-482-6812. And my email is my first initial and last name. So CTABARI it's J Supple Law. So it's JSUPPLELAW.com.
Thank you. That's all I needed.
Thank you.
All right, thank you very much, Mr. Peters. For the panelists, I understand that the closed session will be via a different WebEx link, so I will see you there.
Judge Gavin, before you leave, if you could confirm, I just sent you a email. It'd be from messenger@webex.com, and it should be titled Closed Session Deliberations.
Yes, I have it. Thank you very much.
All right, that meeting's open. We'll see you there. Thank you very much.
Thanks.
And I'll point out for the public attendees who have been watching the oral argument here, we do have to adjourn this meeting at this time to free up the audio video equipment here in the room. So we will not be returning to the open session to adjourn. That's the final item here on the agenda. So please feel free to disconnect, and a full board meeting starts tomorrow at 9 a.m. Thank you very much.